Hey there. So today we are returning to that wonderful world of litigation, to a filing that takes the gloves off. And it's in response to another filing the other day, which I'll show you some of, because man, this is definitely something that people brought on themselves. Ty Beard takes the gloves off because the other side, they've been playing an interesting game, going out and filing things very late, only to say when someone else comes in and says, hey, this is 15 minutes late here, bam, you got to knock that out. So it's going to be an interesting filing on both sides. Before we get into that, however, if you like this kind of content or enjoy the channel, build an extension on the house and move that sucker in. No, if you like it, definitely subscribe, hit that bell, all of that. You know the drill. If you want to go further than that, you want to help the channel out, there are a few ways to do so. PayPal, Patreon, and the case of the Littlest Umbrella. Now, the Littlest Umbrella, it's basically our first foray into comics. It's done remarkably well, and people, they don't like that. They don't like it because it's not only a good product, but it comes with a powerful message. We don't have to lockstep to anyone. Now, if you don't want to lockstep with them, you want to join us in this, well, stay tuned to the end of the video to hear more on that. So, like I was saying here, this is an interesting filing, and it joins us because of this filing. Now, this filing, if you don't remember, basically this filing throws a fit because it says fraud. It says something's late. It goes out of its way to knock out specific documentation when you look at it. And what it's based on here is a date and time submitted. You'll see that they're saying here that this thing is 15 minutes late. Now, in response to that, and you're going to get a response to that, you get this. Plaintiff's amended motion to strike or disregard defendant's late filings. To the Honorable Judge of said court, Plaintiff Vic Mignogna requests that the court strike the documents defendants filed in support of their TCPA motion to dismiss, which were filed after the deadline to file their motions to dismiss, and disregard for the purposes of its TCPA analysis all affirmative defense filed after the deadline for their motion to dismiss. Ooh, this is looking like it's going to be interesting. So, we're going to get some timelines on this. And remember, 15 minutes matters, right? 15 freaking minutes matters. So, the deadline for Defendant Funimation Production LLC's or Funimation's motion to dismiss under the Texas Citizens Participation Act or TCPA was July 15th, 2019. Funimation filed its motion to dismiss on July 1st, 2019. All right, so we're still in there good. Then we get to the subsequent filing. The Funimation subsequently filed Funimation Production LLC's supplemental brief in support of its TCPA motion or Funimation's first supplemental on July 29th, 2019, i.e. 2 weeks after its motion to dismiss deadline. So, 15 minutes matters. Well, what about 14 days? And filed Defendant Motion Productions LLC supplementals evidence in support of its TCPA motion to dismiss or Funimation's second supplemental on August 6, 2019, i.e. 3 weeks after its motion to dismiss deadline. You know, but 15 minutes matters, but this should be okay. The deadline for defendant Real and Toy's motion to dismiss under the TCPA was June 18, 2019. Plaintiff agreed to a joint motion and agreed order extending this deadline to July 19, 2019. Real and Toy filed their motion to dismiss on July 19, 2019. Subsequently, Real and Toy filed defendant Monica Real and Ron Toy's supplemental affirmative defense on July 26, 2019, i.e. a week after the deadline for their motion to dismiss, and defendant Monica Rial and Ron Toy's supplemental to motion to dismiss on July 30th, 2019. So again, remember, 15 minutes matters, but 11 days, you should overlook that stuff. We've also had some interesting things with this too, like not responding to requests to provide information. Some of those things have not been supplied at all. In fact, if you want to go back and you want to look at a letter that came with this before this popped up, well, let's check that out together. Now, this is one of the things that came up during the back and forth, and I thought this was very telling because it said, hey, if you want to get into this, then we'll get into this. This was kind of a promise there. And well, Ty Beard, good to his word. So let's check that out. There's been no fraud. The affidavits were mistakenly submitted with defects in form. This is my notice that we're withdrawing them. I'll serve notice tomorrow, but this email is sufficient notification. No harm has been done to your clients, and the declarations in our second amended petition are identical to the defective affidavits with one very minor exception. Mr. Mignana's original affidavit incorrectly stated that he was prescribed a certain medication as a result of the acts of defendant, so that statement has been omitted. Otherwise, the declarations have the exact same statement as the affidavits, and we are allowed to amend our petition before the hearing. Indeed, the case law seems to almost demand it, so there is no legitimate basis for you to file motions to strike them. Your remedy is to object to the affidavits as being defective in form. You go through, the law on that and so on, and then we get into this. Of course, there's no need to do that since we've told you that we're withdrawing them. And if you want to get into a sanctions fight, so be it. However, given your client's rampant discovery abuse, for instance, Rial testified several times that she gave important information to her counsel that was not produced to us, the revealing of sensitive information about Mr. Mignana in your pleadings in violations to your numerous violations of, I don't think you're going to get much traction with the court. There are also rumors that Mr. Toy has been contacting witnesses and trying to induce them to alter testimony, and threatening them with retaliation if they don't. While I have not credited these rumors up to this point, I will of course look very closely into them and it goes on from there. Man, so you knew what this could lead to, and yet we had document after document taking the low road out here. Now, additionally with that, the defense has asked that plaintiff pop up in court today. So that's kind of interesting too. We have people behind the scenes, a certain Ron Toy, talking about, hey, wait till you see what comes next. So these people, they're gaming out there. And I think things as they move forward, they're going to get interesting. But continuing on here, argument and authority. A motion to dismiss a legal action under the TCPA must be filed no later than the 60th day after the date of service of the legal action. The issue here is whether the TCPA permits supplementing a motion to dismiss after the 60-day deadline is passed. The TCPA does not state whether supplementation after the 60-day deadline is permitted, unlike, for example, the procedural rule governing summary judgment motions, which permit the filing of supporting evidence up to 21 days before the motion's hearing. Rather, the TCPA imposes an express deadline for filing the motion to dismiss based on the date of service, and reviewing courts consistently have held that this deadline is firm. So, you got a deadline there? You want to argue over 15 minutes? Well, all right, you're going to have fun with that. And that's how this goes forward. With interpretation of that, they talk about how the TCPA unambiguously states that a motion to dismiss must be filed by a date certain, 60 days after service, and that a hearing must be conducted by a date certain, but it does not state the supplementation is permitted after that deadline. So it's going in and asking here, what is the point of a deadline if the movement can continue supplementing after the deadline? If you have something that's supposed to be a firm deadline, then how can you continue to go in, add to it, and add to it, and add to it? Again, what's really interesting, like I said, is all of this stuff stacks up together. And well, you see what came first. I mean, when we're talking about the chicken or the egg, definitely this chicken right here, it decided to go out. It decided to play a game that, when you get down to it, it has been in violation of repeatedly. But hey, I don't know anything about that. I mean, you can go out and look at that law Twitter, and they'll tell you how this case has been lost again and again and again. But anyhow, you tell me what you think about this stuff. So like this kind of content? Well, there's a few ways to support the channel. One of those is the Case of the Littlest Umbrella. This is our foray into independent comics, and well, it's been met with a lot of resistance. But hey, you folks are the ones that make it possible, so I thank you for allowing us to hit all these milestones and to continue to move forward. Right now it's in demand as we work on 3 stories attached to the main book, and there's an Ashcan book as well. So on this, you have an all-ages Lovecraftian tale. That's our main tale here. We added another tale called Dino Island, which there are pictures in the updates section. You can just click on that and check those out. We've added another tale as well as a thank you since we passed our last milestone. That it may not be exclusive to this book, but it is going to be a fun one, and it's been greenlit because of this book. This also is the Ashcan. It talks about all the things that went on in comics. Make sure you check all of those out. You may be interested there. You also have original art tiers. That's actually a really good price on those. You know, Peter Gilmore is doing those, and he usually does not do them for where you're getting that at. Now, we're talking about all of this stuff that's come up here too. Let me know what you think about these 2 filings. I mean, when you look at this, I'm not surprised by this, and well, you know, there's going to be responses. I mean, if you want to play with that, if you want to go out and say deadlines matter, then deadlines matter. Leave me your comments, pro and con, ending this too. While these companies and these voice actors, they forget who goes out and who pays them to exist. Well, we don't need to do that. So I want to thank you for showing up. I want to say I appreciate you. We'll be doing this stuff very soon, so join us with that too.